Please write the case name. Patanjali Foods Limited, formerly Ruchi Soya Industries Limited versus Union of India and others. Other than that, please go on revising each and every case law which you have already covered or we have covered in our classes, because each and every case law has been picked up thinking and assuming the fact that what is held by the Supreme Court or what are the precedents referred over there are very important from an exam perspective. So our basic motto is going ahead and giving you a heads up regarding your exam. Even if you attend these classes, make a note of it, it will not serve the purpose because you need to revise. Fine. Please remember this statement that law is a jealous queen. Law wants your attention. If you don't give that attention, it will not be helping you in the exam. Let's start with the class. So in this case, the Supreme Court has to deal with a very simple question as to encashment of bank guarantee. So whenever any amount is being given to the revenue department, I'll just say, Abhi, iske liye just listen to me. We'll deal with the facts and everything. So in case any amount has been given to a revenue department and that department, without going ahead with the finality of the judgment, thereby simply encashes the bank guarantee, whether that bank guarantee would be justified. So simply over here, we need to deal with a simple question, whether any authority, for over here we'll be dealing with tax. So whether the authorities under the Custom Act, that is the Revenue Authority, has a right to encash the bank guarantee where that bank guarantee is not given as a duty. Where that bank guarantee is not given as a duty, but simply as a security. So whether can a revenue department simply go ahead and encash it? So that is the thing which we'll be dealing over here. Or while going ahead and encashing that bank guarantee and thereby going ahead with a refund. See, if that any amount has been given to me, being a revenue department or being a government authority, if that amount is given as a mere security, but not as a duty, or which is not as a tax which has been paid to me, and on that bank guarantee, I'm simply going ahead and encashing it. Now, this is an inappropriate act of me. Right? This is something which is inappropriately done by me. I had to go ahead with a refund of that amount because that was a mere security, but not any duty or a tax. Now, while I, as a government or as a revenue department, I am refunding this amount, whether now the provisions of the law will be applicable thereby or not. So in this case, there is this thing whereby this person over here, the appellant, has given a security, and for that security, for maintaining that security, he had gone ahead with the bank guarantee. That bank guarantee was encashed by the authorities. After the encashment, he is claiming the refund. Please return me that money. Okay, now he is claiming the refund. But the authorities are saying, no, I will not refund you like that. Go ahead and follow the procedures of law. So the court over here, the Supreme Court over here has to deal with a simple issue. While there is an encashment and the other part, then when there is a refund of that encashment, will the authorities of law to be followed? Or these provisions of law to be followed or not? If these provisions of laws are made only applicable in the cases where there is some tax paid or a duty paid inappropriately, then only if there is a refund, then only these provisions will come into hand. So whether a simple security paid by any person towards maintaining the norms of the High Court, the order of the High Court, will that also go into the fact that the provisions of law will counter the refund procedure which has to be made by the government? Abhi ke liye thoda samajh mein aaya what is going to happen. Now let's just see the facts. Please be with me, because there are many times when the High Court is being approached there are many times when the Supreme Court is being approached. So please read the facts correctly, and if you have any doubt at any moment, just ping me over here. Now going ahead. So over here, MP Glychem Industries Limited just a second, imported certain quantity of crude soybean oil of edible grade, but the customs department did not clear the goods on the ground that the appellant was required to pay higher custom duties on the basis of tariff value fixed or for the imported goods under section 14 subsection 2 of the customs act. वेरी सिंपल, इंपोर्टिंग हो रही है किसी चीज की, उसके ऊपर आपको कस्टम ड्यूटी पे करनी होती है बिकॉज यू आर इंपोर्टिंग फ्यू एनी आइटम फ्रॉम द आउटसाइड. So now over here the custom authority has taken the custody of that item, stating that you have not paid your duty properly. You have not followed the procedure or the duty which has to be paid, which has been fixed under section 40 subsection 2 of the Customs Act, and thereby we will not be discharging these items to you. Now, section 14, subsection 1, subsection 2 are not for our consideration. उससे आप इतना समझ लो, there are few duties or valuation of the goods. Under section 14, we deal with the valuation of the goods, and accordingly some duties are being fixed by the customs authority. Fine. Now, over here, the appellant challenged this act of the customs department in High Court and contended that at the time of the import of the goods, the concerned notification under section 14 subsection 2 of the Customs Act had not come into effect. It is simply over here the appellant is challenging before the High Court that the section 14 subsection 2 of the Customs Act was not in force at the time when these item, or you say this oil was imported, right? अब जब कोई चीज का नोटिफिकेशन नहीं आया, कोई चीज का एप्लीकेशन नहीं था और कोई एक्ट प्रायर टू द एप्लीकेशन हुआ है, बट आफ्टर इट हैज कम इनटू फोर्स, जब वो एक बार उसका चीजें हो ड्यूटी पे हो चुकी है उसकी, अब नाउ इट हैज बीन इंपोर्टेड, नाउ विल द प्रोविजन will have a retrospective effect or a prospective effect. Every time it is stated that every provision of the law will have a prospective effect. It will not have a retrospective effect. Simply over here, appellant is challenging the customs department action, whereby they are claiming this notification was not over there when I imported the goods. Abhi, it is over there, now it has been notified, but now I cannot go ahead and pay accordingly. I have already followed the procedure, or I had paid according to the valuation given under section 14 subsection 1. According to subsection 2, I am not liable to pay. Fine. Therefore, the appellant was liable to pay duty only in terms of section 14 subsection 1 of the Customs Act. High Court admitted the writ petition and granted interim relief. It has simply granted interim relief for clearance of the goods. कि भाई just clear the goods, don't hold those goods. And further, appellant should further ordered that the appellant should furnish a bank guarantee for the difference of duty of customs under section 40 subsection 1 and subsection 2 of the Customs Act. Over here, High Court had taken up the writ petition and on a very prima facie basis and stated and ordered two things. Ordered the department that please release the goods to the appellant, and secondly, ordered the appellant please give me a bank guarantee. Of what amount? Of the difference of amount which has been created under subsection 1 and subsection 2. Fine. Clarifying. Now, the High Court has even clarified that this arrangement would be subject to the order of final assessment, which was thereby furnished by the appellant. So whatever order was given to the appellant to furnish the bank security, appellant had thereby furnished the bank security. Are we clear till now? There is an import of oil. On those import, custom authorities stated that proper custom duty has not been paid, and thereby we will not release these goods to you. You are required to pay as per section 14 subsection 2 of the Customs Act. The appellant had challenged this action of the custom authority before the High Court. High Court had given the interim relief, whereby, okay, I am just repeating it again. So High Court over here, accepting that thing, has given her interim relief, whereby it had immediately asked for the release of these goods to the appellant, and appellant has to furnish the bank guarantee. That bank guarantee is on the amount of the difference between subsection 1, according to which the appellant had already paid, and subsection 2, which the department is asking. Now, the claim of the appellant is very simple claim and very logical claim. Why was it? Just because this is an interim relief. In case after the analysis of the High Court, it is found that the custom department had done their job correctly, section 14 ka subsection 2 is applicable, then somehow something has to be before the High Court itself, right? So then they'll release this amount. Ki bhai, this is the custom authority demand. Because abhi custom authority had nothing to hold upon. The goods which they have has already been released. So custom authority had nothing to be hold upon. So something to be hold upon, to be taken into consideration, that is the bank guarantee. Many a times, whenever there is a monetary cases involved, the courts go ahead and taking up some of the security amount in hand. In case of any default, in case of anything, they'll simply release that amount. So that is the main purpose. So yes, appellant had challenged on a very logical way that this notification of this subclause subsection 2 was not applicable when I imported it. Now please don't go ahead and apply this provision over here. Taking that logical input of the appellant into consideration, the High Court had issued only an interim relief. Now, in the meantime, when these proceedings were going ahead, the MP Glychem Industries Limited merged with Ruchi Soya Industries Limited. As you see the case name over here, it is Patanjali Foods Limited, formerly Ruchi Soya Industries Limited. Fine. Just to clear that, कि भाई ये कहाँ से name आ गया, इसलिए मैंने ये चीज लिखा है. So, the High Court is going ahead with the proceeding, right? So the writs were dismissed by the High Court. While analyzing the writ was actually dismissed by the High Court, and the relief stood vacated. So the relief diya tha of going ahead with any, bhai, just release the goods and everything, that stand vacated. That is not going to be followed now. Agreed by this order of the High Court, appellant approached the Supreme Court under civil appeal. So now, while aggrieved by this order of the dismissal of the writ, the appellants are going ahead and approaching the Supreme Court under the civil appeal. During the pendency of this appeal, the department encashed the bank guarantee. So following the High Court's order, that High Court had already dismissed the writ, what department did over here is going ahead and cashing the bank guarantee, without taking into consideration that there is some civil appeal before the Supreme Court which is already pending. Fine. Supreme Court held. Supreme Court had decided upon this civil appeal and held that it was not justified and lawful on the part of the department to claim the differential amount of duty on the basis of the said notification. Thereby, appellant filed for the refund. Now, over here, the Supreme Court, while dealing with the civil appeal, had stated that the act of the High Court was erroneous. The High Court shouldn't have taken up the bank guarantee on the differential amount. Up thereby, when Supreme Court has stated that, appellant went ahead for the refund. On such refund, the Custom Department issued letters raising concerns. So when the refund was made, the application for refund was made before the department had issued letter raising few concerns. The first concern was that the refund application was not under the proper format. So they were saying you are not following the proper format. And secondly, there is non-submission of balance sheet, profit and loss account, etc. So over here they are stating that you haven't submitted the proper documents which are required to be submitted. Under section 27, when you are claiming for a refund of duty, then the person who is claiming so is required to go ahead and with the application of refund, you have to file the relevant documents. These relevant documents are the balance sheet, profit and loss account, etc. for the relevant period. Now, why it has to be given, why these documents are so important? To show, very important line, to show that the claim of refund is not hit by the principle of unjust enrichment. Now over here, now let's just understand how is unjust enrichment theory has been inculcated while going ahead and taking up the refund. Why? Because once there is a custom duty which has been paid by the seller over here, then the seller will go ahead and impart this custom duty to the other customers. Matlab, for example, if there is this good of rupees 100, I have paid custom duty of 20 rupees. Then I'll make sure when I'll go ahead and sell this product to my customers, I include that 20 rupees over here. I'll shift that burden of revenue burden from me to the customers, right? If that is done, if I have already claimed my 20 rupees which I have paid to the custom duty from the customer, and now I'm going ahead and taking the refund of my 20 rupees from the custom authorities also, I'll be have a benefit of 20 rupees, right? Unjust enrichment nahi hona chahiye. Court is stating, the law over here simply 27 states, whenever you are claiming the refund, you need to show to the custom authority that you are still under the burden of that custom duty. You haven't shifted that burden to your customers. You are still indebted 2 rupees 20. So over here, when I'll be going ahead and filing the refund, मैं बैलेंस शीट दिखाऊंगी ना, मैं दिखाऊंगी अपने प्रॉफिट एंड लॉस की, देखिए मैंने जो 20 रुपीज था वो मैंने अपने कस्टमर से नहीं लिया है, वो अभी भी मैं आपसे ही मांग रही हूँ कि गिव बैक माय just a second. So over here, the person has to show, the seller over here has to show the assessee for the matter, for the tax matters, you can say assessee. So assessee has to show one single thing, that I haven't shifted the burden of that custom duty towards my customers. It still is upon me, and thereby I'm claiming payback of that amount. Are we clear? So how this unjust enrichment comes into play? Do you know this doctrine? Have you studied about this doctrine? I'll give you a hint. Under your Indian Contract Act, we deal with unjust enrichment. Unjust enrichment is nothing but getting the benefit unfairly. Fine. अभी तक वो यहाँ तक तो हाई कोर्ट के ऑर्डर तक क्लियर था. Let's just go ahead with the other thing. Once the High Court was approached, High Court, after giving the relief, interim reliefs, had dismissed the writs and thereby stated that all my reliefs should vacated, will not be in use. Thereby, aggrieved by the order of dismissal by the High Court, the appellant are approaching the Supreme Court under the civil appeal. While there was a pendency of the civil appeal before the Supreme Court, the Revenue Department went ahead and encashed the guarantee. Let me just complete the facts and then I'll come to you, Aditya. Fine, over here, they cannot encash the guarantee. After the analysis and everything, the Supreme Court gave its judgment, whereby it held that it was not justified of the High Court, thereby claiming the differential amount. And thereby, on that fact that the Supreme Court had held in the favor of appellant went ahead and filed the application for refund from the Custom Department. The Custom Department had issued letters of concerns that there were these faults. What are two major faults? Firstly, proper format of that application was not followed. And secondly, even if that proper format was followed or not, you haven't filed with the relevant documents. These relevant documents are very important to analyze whether the person who is claiming the refund had not shifted the burden to the other party, and now is not claiming and taking profit from the customs authority as well. Now, coming to Aditya's question, so the applicant cannot claim their refund without any proper reasons. Obviously, why will you claim refund? The problem is, or you can say the provision is, that the customs duty has to be paid, the taxes has to be paid, right? While you are importing anything, when you are buying something. If there is no improper way of taking up the taxes by the authorities, why will you go ahead and take the refund? It is only when there is a misapplication of your provisions. If it has been galti se le liya ho unhone, that was not needed. For example, the custom duty to be paid over here was 20, but after analyzing the fact, they have went ahead and taken up 40 rupees. This is misapplication of law, misinterpretation of law. And then thereby I am eligible to get back my 20 rupees. Right? But I'll not get back my 20 rupees if I have shifted that 40 rupees ka burden, or 20 rupees ka burden on my customers, and I have already took profit from them. If I had gained profit after selling the product for 140 rupees to my customers, though it was should be 120 rupees plus my profits, but if I took it as at amount 140, then why will I go ahead and take the refund? Right? So this is unjust benefit. The court says that even if you want a refund, you need to show that you are still burdened by rupees 20 or by rupees anything which has been improperly taken by the court. This is something which is abhi ye Supreme Court ka final decision nahi hai. Fine, this is not the Supreme Court's final decision. Now the problem is arising over here. When the department had issued letters of concern and stating please file the relevant documents so that we can see you are not gaining profit after claiming this refund from the revenue department. Aggrieved by the continuous demands of the document, a special leave application was filed before the High Court. Aggrieved had again went ahead to the High Court under the special leave application. Whenever these demands were continuous, because they aggrieved had also claimed, the appellant over here has also claimed this issue ki please don't ask for the documents over here, we haven't paid the duty to you. Okay? Still the department was saying if you want refund, file the relevant documents. So aggrieved by this fact that they are claiming continuously their documents, they went ahead and filed a special leave application before the High Court for quashing the letter and direct refund. High Court dismissed the writ petition and left it open to appellant to produce document before refund. Even High Court had dismissed the writ petition and stated कि appellant, it is up to you. If you will file the documents, if you will give the proper documents, then only refund can be made. So it was clearly open to the appellant to file the documents. Now aggrieved by the decision under special leave application made to the High Court regarding the documents, an SLP is filed before the Supreme Court. Now we'll have to deal with a very important question, that is whether doctrine of unjust enrichment or section 27 of Customs Act applies in cases of encashment of bank guarantee which was given as security. अब do you understand? Over here जो यहाँ पर बैंक गारंटी दी गई थी, it was a mere interim relief, right? There was a mere interim relief which was issued by the High Court on the writ petition कि please give that guarantee on the basis of security. This was only a security but not a duty which is required or taxes which is required to be paid to the Customs Department. Understood? So now the question comes whether now can department can encash this, and still after encashing, when the refund is being claimed, they have to go ahead with the procedure. Let's see whether you haven't got any unjust enrichment or section 27 will apply, whereby you are required to file the documents. This is what the Supreme Court is dealing in this particular case which is before us. Are we clear till now? If not, तो आगे की चीजें समझ में नहीं आएंगी. So yes or no, why or n? What issue? Tell me, Shalini. What? Explain again. Should I explain the whole case to you? The issue which is to be decided by Supreme Court. These are the statutes which are relevant. We have dealt with these two. We will be dealing with this again. Fine. So over here, the Supreme Court has to deal with a very simple issue, that when any authority has encashed any guarantee which was given as a merely security to the High Court for proceedings, when any amount as a bank guarantee is being given to the High Court for a mere security basis for dealing with the cases, not as some taxes which are required to be paid to the department. Can the department go ahead and encash it firstly? Can they go ahead and encash it and take the amount in their own account? And if they have done so, while an application for refund has been made to that department कि please आपने गलत act किया है, refund my amount, Now the department is required to follow the doctrine of unjust enrichment or section 27 for that matter of the Customs Act, whereby they are now, the burden is upon the appellant to show that I haven't shifted this burden of the differential amount which I have paid as security to my customers. I still hold upon that burden on my shoulder. So is it the appellant's duty or a burden which is required to be taken up? Because the thing is, if it was a duty or a tax which is being paid to the customs authority and then a refund has been claimed कि आपने inappropriate मुझसे amount ले लिया है, तब तो ये बनता है 27 will apply, unjust enrichment will apply, because the the amount which was paid was a duty or a tax. But in case it was a mere security given to the High Court, and on that basis you are going ahead with encashment and now claiming the documents to prove that there was no shifting of burden, I'll not be getting profit if you will give me a refund. Is it proper action of the department or not? That is what the Supreme Court has to deal in this particular case. There are different valuations of goods. Abhi itna in depth, don't go ahead. If you want, you can read the section, though it is very improper, or I can say it's useless for your exam perspective. It simply deals with two things. कि इस kinds of goods के लिए इतना valuation kind of आप लगाओगे, तो actually कुछ नहीं लिखा है, it is just the interpretation. And the second is import हो रहा है, ये सब हो रहा है, तो इतना लगेगा. So there are two different provisions dealing with the valuation of goods. Now moving ahead, are we clear, Shalini? Are we clear with the issue? This is very important case law. Please remember the case name. प्लीज रिमेंबर द केस नेम, क्योंकि ये पहला कोई एक केस है जो कि हम टैक्सेस रिलेट कर रहे हैं. और देखो बात ये है ना, अगर मैं बात करूं तो इंसॉल्वेंसी, टैक्स लॉ की, इन्वायरमेंट लॉ की, इसके सुप्रीम कोर्ट के केसेस बहुत कम आते हैं, साल भर में भी बहुत कम आते हैं. राजस्थान हाई कोर्ट, ये सब हाई कोर्ट के केसेस ना बहुत मिल जाएंगे, सुप्रीम कोर्ट के केसेस कम आते हैं. इसीलिए इट बिकम्स वेरी इंपॉर्टेंट फॉर यू टू अंडरस्टैंड द इश्यू, द फैक्ट्स एंड एवरीथिंग, क्योंकि ये सब क्वेश्चंस ही तो आएंगे पूरे एक साल का. आपको पता है ना, लैंडमार्क केसेस तो ऑल ओवर, जहां से स्टार्ट हुए जहां से एंड हुए पूरे आते हैं लैंडमार्क केसेस. रीसेंट केसेस हमेशा लैंडमार्क केसेस पे ही रीसेंट केस बेस्ड होता है, या रीसेंट केस पे ही लैंडमार्क केसेस बेस्ड होते हैं. तो 1 ईयर का आपको पूरा एक बैकलॉग लेना पड़ता है टू अंडरस्टैंड व्हाट आर द रीसेंट केसेस ऑन डिफरेंट सब्जेक्ट्स. सो अकॉर्डिंगली दिस इज वन ऑफ द केसेस वी आर डीलिंग. अभी वी आर इन जून, अभी हमारे पास समय है. अगर कोई अच्छा टैक्स लॉ का केस आएगा तो वी नीड टू डील विद दोस केसेस, क्योंकि हायर चांसेस है कि यही सब आपके एग्जाम में पूछे जाए. फाइन. नाउ गोइंग अहेड विद द ओपिनियन ऑफ जस्टिस अभय एस ओका, whereby court stated, please be with me, have your full concentration. Court stated, section 27 of the Customs Act and section 11B of the Central Excise Act. तो यहां पर मैंने 11B भी लिख दिया, जो कि क्लेम ऑफ रिफंड की बात करता है, एक्साइज की. ठीक है, बोथ आर सेम बट डिफरेंट टैक्स, टॉकिंग अबाउट द रिफंड बट ऑफ डिफरेंट थिंग्स. यहाँ पर ड्यूटीज का रिफंड, यहाँ पर एक्साइज ड्यूटी का रिफंड. फाइन. So court over here stating that section 27 of Customs Act and section 11B of the Central Excise Act deal with the question of refund. Refund can be denied either in part or wholly by applying the doctrine of unjust enrichment. तो सबसे पहले स्टार्टिंग में ही सुप्रीम कोर्ट ने बोल दिया, even if the SSC is asking for the refund, it can be denied either wholly or partly on the basis of doctrine of unjust enrichment. Very correctly said. Because under section 27 or 11B, the refund is of any duty which has been paid, any excise duty or a tax which has been paid, for which the assessee is asking for the refund. And for that matter, doctrine of unjust enrichment will apply. The basic thrust of the aforesaid provision is that any person claiming refund of any duty may make an application for refund of such duty and interest, if any, if he had paid the duty in pursuance of an order of assessment or bond by him. So any duty which he has paid during the assessment or which he was bound by, meaning he was burdened with. So if he has paid, then he can simply go ahead and file the application for the refund. application should be accompanied by relevant document and evidences. This is yet another important provision of section 27. But now let's just deal with the current case. The High Court in this case, in this particular facts, had placed reliance on a two-judge bench decision of DCW Limited versus Union of India 2016. I'm so sorry. DCW Limited versus Union of India 2016 and held. So the High Court, taking this High Court before us, had took the reliance of DCW Limited versus Union of India 2016 judgment, which is of two judges bench, and held that the doctrine of unjust enrichment would be clearly applicable. So over here, the High Court, while dismissing the writ petition, took the support of the precedents of 2016 and thereby stated that the doctrine of unjust enrichment will apply in this facts of the case of the appellant. Therefore, burden would be on the appellant to establish that it had not passed on the duty to third parties. Now it is the burden upon the appellant's shoulder to prove that he hadn't passed that duty to his customers. But Supreme Court is giving their own opinion. But we are afraid High Court erred in placing reliance on this said decision, as in that case, the court which had permitted the revenue department to encash the bank guarantee after vacating the stay order because of persistent default on the part of the applicant in paying the duty. So over here, Supreme Court is giving opinion that though under 2016 judgment, the court has allowed the doctrine of unjust enrichment to be applicable in that case, while going ahead with the refund of duty. In this particular case, what is happening? So what were the facts of that case? Was simply the party or the assessee was continuously doing default. Yes. There was persistent default on the part of the applicant who was going ahead with the refund. And thereby, sorry, why I'm saying refund over here. I'm so sorry, this does not deal with refund. This does not deal with refund or something like that. Give me a second. मैं खुद confused हो के मैंने आपको confuse कर दिया होगा अब. Give me a second. Let's just read the case again. Held that the doctrine of unjust enrichment would be clearly applicable. Therefore, burden would be on the applicant to establish that it had not passed on the duty to third parties. But we are afraid High Court erred in placing reliance on the said decision, as in that case, the court which had permitted the revenue to encash the bank guarantee after vacating the stay order because of persistent default on the part of the applicant in paying the duty. Okay, fine. Yes, it is regarding the refund only. There was this security taken up, but that security by the High Court was taken up because of the simple reason that the applicant was doing a persistent default, and thereby they had ordered the revenue department to go ahead with the encashment of guarantee. The simple word which is required to be seen over here and to be interpreted by you all is the duty. That there was default on the part of the applicant to pay the duty, and thereby the High Court had ordered to go ahead and please, I'll dismiss the writ petition over here and go ahead, department authority, and encash the bank guarantee. But in so far the present case is concerned, now let's just deal with the present case. It is true that the initial rounds of litigation, High Court had dismissed the claim of the applicant. After the High Court had dismissed the writ petition, applicant had filed special leave petition before this court. So, taking the facts of this case in our hand, there were few rounds whereby High Court had dismissed the writ petition. But after the dismissal, the Supreme Court was approached by the applicant. Without waiting for the court to take a decision, revenue displayed extreme haste and encashed the bank guarantees. The court is stating, while we were simply dealing with the case, इतनी जल्दी थी हमारे revenue department को कि they went ahead and encashed the bank guarantees. It is thus evident that the respondents had recovered the differential duty amount by adopting coercive method, that is, encashment of the bank guarantees which were offered as security. So the revenue department went ahead and take up the encashment the encashment which was offered as a mere security for the differential amount of duty on order of the High Court. So was it a requirement under law that this has to be done? No, it is something which the High Court had ordered the appellant, please go ahead and give the differential amount as a security, not as a duty which is required to be paid, but as a mere security. Okay? The key word in section 27 of the Customs Act is paid. Refund thereunder is permissible only if any duty is paid by the claimant, which subsequently becomes refundable either wholly or in part. So under, if you understand section 27 well, it is said कि भाई जो paid हुआ है, the paid over here has to be refunded. Nothing was paid. It was merely a security which has been ordered by the High Court. Fine. In the fact of the present case, encashment of the bank guarantees offered as security cannot be treated as a payment of custom duty. Very important. So the encashment as a जो कि offer हुआ था security cannot be treated as a payment of custom duty. This is very important for you to understand कि basics क्या है. अगर आप facts clearly पढ़ो तो वहीं पर दिया हुआ है कि please give the differential amount as a bank guarantee. Why? What was the motto? Interim relief थी ना. What was the motto of High Court ordering that? Merely as a security. कि in case कल कोई default होता है, कल कुछ भी होता है, तो I'll go ahead and allow this amount to be encashed by the department. But department should also take into consideration that there was no final judgment by the Supreme Court. There was a pendency of the civil petition. क्रिमिनल क्या था, हाँ सिविल थी ना, तो सिविल पिटिशन वहां पर still pending थी. So for that matter, over here, department should have not gone ahead of their time and of their authority in encashing that amount. Acha, let's just refer the cases before going ahead with the last passage. Very, very important case law. Please remember the case name, Union of India versus Param Industries Limited 2016. Please do remember this case name. Court held that though the notification might have been published on the date when the goods were cleared. So court over here is stating 2016 का judgment है कि though the notification of any provision might have been published on the date when the duties were cleared, it was not offered for sale by the Central Board of Excise and Customs Act. So over here, the board had never went ahead and even if it was published, it was not executed, and both are very different terms, right? There are times when the provisions get published but are not executed. And similarly over here, even if there is this provision which got published but not executed, you cannot apply that provision, right? Which event took place much thereafter. So the event of going ahead and executing that provision took way later. Therefore, it was not justified and lawful on the part of the department to claim the differential amount of duty on the basis of the said notification. Because there was a release of a notification but no application of it, there was no such particular authority which has authorized the custom department to go ahead and realize the differential amount. This is very important case. इसमें simply ये बोला गया है कि anything which is published does not per se means executed. ठीक है? It will not per se means executed. Mere notification does not show that the authorities have the power to realize or apply that notification. It is upon the board. It is always upon the board to go ahead and say कि भाई अब ये for sale हो गया है, और अगर हम legal term में बात करें तो for execution हो गया. You can execute this notification. Now, going ahead with yet very important case law on which a total reliance of this Patanjali Foods wala case, जो भी the case which is we are dealing, has took the support of this case itself. So Oswald Agro Meals Limited versus Assistant Collector of Central Excise Division, Ludhiana, 1994 case. Very, very important case. Please remember these two case names. The court held that the doctrine of very clear words. अगर हाई कोर्ट एक बार 1994 का ये केस देख लेता तो उसको आसानी रहती, और इतना बड़ा मैटर होता ही नहीं, बट नहीं देखा क्योंकि बहुत क्लियर वर्ड्स में लिखा था held that the doctrine of unjust enrichment will not come into play when bank guarantee is offered as security, and the same is encashed by the revenue after the case is lost by the assessee. Even if there is the assessee, the judgment of any court is not in the favor of assessee, still the department has no authority to go ahead and encash the bank guarantee on the mere basis because it was given as a security. Further, that it is cannot be said that the assessee had paid the amount as duty. Therefore, such encashment would be out of scope of unjust enrichment. And thereby now there is no burden upon the appellant's shoulder to go ahead and prove through the documents that there was no unjust enrichment. Understood? In Oswald Agro Mills case 1994, in a very clear terms it is stated whenever a bank guarantee is issued as a mere security, even if the judgment was not in the favor of appellant, still the department has no authority to encash it, because of the simple reason the amount or the bank guarantee was for the security and not for any duty which is to be paid. Firstly. Secondly, once this is done, if this is a security which is paid and not a duty, then there is no question of section 27 coming into picture or the doctrine of unjust enrichment coming into picture, whereby now the department will shift the burden on the shoulders of appellant to prove that you haven't earned or you haven't shifted that burden towards the customers. So there is no requirement of the appellant while going ahead and claiming the refund to show the profit and loss balance sheets and thereby proving that they haven't earned any unjust enrichment. Understood? Are we clear? Very important. And this case was endorsed in your Somaiya Organics India Limited versus State of UP 2001. And for that matter, please remember this case name as well. Remember Oswald Argo, kabhi examiner will go ahead with this case. Fine, they'll go ahead with this case and they'll ask which is the recent case law on this matter. So you must remember today's case law. Patanjali wala, you need to remember it. क्योंकि वो याद नहीं रहेगा तो कैसे कर पाओगे? क्योंकि Supreme Court had took a proper reliance, a full reliance on of this 1994 judgment itself. Fine, this is one thing. Now, dealing with yet another case, which is Mafatlal Industries Limited versus Union of India 1997. The thing is, court over here was examining the concept of unjust enrichment. So court in this particular case was dealing with the concept of unjust enrichment and thereby considered various questions concerning refund of excise and customs duty collected contrary to law. So they were dealing with the questions in case what will happen in case the refund is made on the basis when the duty is collected contrary to law. So they have laid few principles. Let's read this principle and then I'll tell you what happened. So where the first principle is where a refund of tax or duty is claimed on the ground that there was misinterpretation or misapplying of the provision, such a claim has to be preferred in accordance with the respective enactment. Okay? Before the authorities and within the period of limitation. Very simple. Whenever a refund has to be claimed on the basis of misinterpretation or misapplication of a provision, then where to approach? What provisions to be taken into consideration? That Act's provision itself. So the Excise Act or the Customs Act, ka jo bhi provisions are, that will be applicable and thereby the authorities over there are the correct authorities. The timeline, you have to follow any timeline which is given under that particular act. Very simple. Now, all refunds claim will have to be filed and adjudicated under the provisions of Central Excise Act or the Customs Act. Second provision, dealing with something very in a clear terms. कि जो भी refund आपको claim करना है, please go ahead under the adjudication of the provisions of those act itself. जिसके अंदर आप claim कर रहे हो. Further, where, however, a refund is claimed on the ground that the provision has been held as an unconstitutional. But if you are claiming any refund on the ground that the provision under which the custom duty you have paid or any tax you have paid is held as unconstitutional, then in that case आप उस authority के पास तो जाओगे नहीं. right? That authority, that provision will not apply. Where will you approach? Now you can go ahead and file a suit or a writ petition before the High Court or a Supreme Court. Understood? So the thing is, while going at the first provision, whereby you are claiming a refund on the basis of misinterpretation or misapplication, then you need to approach under the provisions of that law itself. No writ petition or no suit can be filed. But wherever there is an unconstitutionality regarding any provision and then you are claiming a refund, in that case, you can go ahead and file the suit or the writ petition. This is yet another principle, very important principle. Now, going ahead, a claim for refund can succeed. Now, please look at the fourth principle, which is giving the procedure over here. So now, if any party or assessee has to claim the refund, can only be succeed only if the petitioner or plaintiff establishes that he has not passed on the burden of duty to another person. Okay? Over here, they have to prove the unjust enrichment. The doctrine of unjust enrichment will apply in case they are claiming the refund. So if any person wants to claim a refund, they have to go ahead with the burden of proving of section 27 or 11B for that matter. फाइन. तो इस केस में जो पहले वाले 1994 के केस में कहा गया ओसवाल है ना, हाँ ओसवाल आग्रो में, कि भाई वहां पर इन केस ऑफ सिक्योरिटी रिफंड आप ऐसे ही मांगो, कोई अनजस्ट एनरिचमेंट डॉक्ट्रिन नहीं अप्लाई होगी. अपोजिट टू दैट इतनी क्लैरिटी नहीं थी इस जजमेंट में कि सिक्योरिटी अमाउंट है, ड्यूटी अमाउंट है, कौन सा अमाउंट का रिफंड हो रहा है, किस लिए रिफंड हो रहा है, बट नथिंग. बट इन केस ऑफ रिफंड, अगर आप रिफंड क्लेम कर रहे हो, देन यू आर रिक्वायर्ड टू गो अहेड and file your relevant documents and evidences to prove that there was no such unjust enrichment. Fine. This is because where the burden of the duty has been passed on the claimant cannot say that he had suffered any real loss or prejudice. Clearly, if I had passed my duty on my customers, I had no real loss, right? Because now I'll be getting profit itself. Then get another and fifth principle. Though there were 7 principles, I laid down 5 itself, क्योंकि जो 2 और principles है, they are somehow retreating the above principles itself. तो इतना ये केस इतना important नहीं है, but just because we need to understand what over here, because this is one of the precedent which has been referred by the Supreme Court. दो controversies हो गई ना, दो opposite opinion हो गए of the similar Supreme Court itself. 1994 केस में जहां कहा गया नो अनजस्ट थ्योरी डॉक्ट्रिन ऑफ अनजस्ट विल बी अप्लाई. अब ओवर हियर इट इज स्टेटेड कि नहीं, अगर आप क्लेम ऑफ रिफंड कर रहे हो तो आपका डॉक्ट्रिन ऑफ अनजस्ट एनरिचमेंट विल अप्लाई. लास्ट, द डॉक्ट्रिन ऑफ अनजस्ट एनरिचमेंट इज जस्ट एंड सैलिटरी डॉक्ट्रिन. सैलिटरी ओवर हियर मीन जस्ट एंड फेयर डॉक्ट्रिन. It is based on the principle that no person can seek to collect duty from both ends. So it is clearly stating that nobody should be enriched, should not get the benefit of claiming the duty. पहले तो मैंने अपना burden shift करते to my customers and now I am claiming a benefit from the refund itself. That should not be the case. Now please do remember the last line. Pre point of view से या exam point of view से आपके लिए ये important है. The doctrine is however inapplicable to the state. It cannot apply in the cases of state claiming the refund, as the state represents the people and no one can speak of the people being unjustly enriched. ठीक है? So whenever there is a state claiming the refund, in that scenario, doctrine of unjust enrichment will not apply. Fine. Now, court over here. Do you all understood the 5 principles over here? Have you written in pointers basis itself? Because this is very important. इसके बाद आप लिखना जो अभी मैं आपको बताऊंगी, but then still you must remember these 5 principles. क्योंकि कहीं ना कहीं अगर ये केस आ गया और पूछ लिया गया which is the case which has overruled this case, तो भाई अगर यही नहीं पता होगा इस केस में क्या हुआ, और हो सकता है कि स्टेट रिलेटेड कुछ भी पूछ ले, कोई भी प्रिंसिपल पूछ ले आपसे. तो आर वी क्लियर? Yes or no? If not, then I'll go ahead and explain you again. Fine. Up over here, let's see कि why court took the support or the precedent of Oswald Agro Mills and not this Mafatlal Industries Limited. Now, Supreme Court over here is stating that the act of the Revenue Department was the attitude with which the Revenue Department went ahead and encashed the bank guarantee was very illogical, was a very bad attitude on the part of the Revenue Department. What they should have done, they should have waited till the decision of this court. This court, matlab Supreme Court over here. They shouldn't be so hasty in nature whereby they are just simply going ahead and encashing the security amount. With which, taking into that thing into consideration, the best suitable judgment is Oswald Agro Mills, and that is why Supreme Court is going ahead with this case. Though they understood and they laid down these two cases itself, okay, these are the rationales given, and there is a difference of opinion in both these cases. But as Supreme Court, as a fact in this particular case, we are going ahead with 1994 judgment and not with our 1997 judgment. Is 1997 judgment thrown away? No, it is not applicable in our particular case. It is not something which you can overlook because it has simply laid down important principles which are very important while going ahead with a refund of any custom duty. But if we talk about any security which has been paid and not a duty, in that scenario, it is Oswald Agro Mills which is more applicable, and that is why Supreme Court went ahead with this particular case. Are we clear? Shalini, in your Oswald Agro, they were very specific to the matter that whenever any bank guarantee is issued in the cases of security, then no doctrine of an unjust enrichment will be applicable. Over here, applicant is not required to prove that they are unjustly enriched by the fact that they'll get a refund. They are not required to show or go ahead with filing of the documents. But whereas, if we talk about your Mafatlal Industries Limited, the principles are given whereby they are simply stating in case of a claim of refund, the doctrine of unjust enrichment will apply. If you want to succeed with the claim of refund, you are required to prove that you haven't gained any profit by transferring that duty to your customers. Understood? So that is the main difference. If we'll go ahead with Mafatlal, thereby the High Court decision is correct, whereby the High Court has stated it is upon the appellant to file the document because that is one of the requirements. So the High Court is correct in taking up DWC ka judgment of 2016 of two judges bench, whereby the court over there stated the Revenue Department can go ahead with the encashment because there is a default on the part of the assessee in paying the duty. But there was no default because if we take ahead Union of India versus Param Industries Limited, which simply says if there is a publication of notification, that simply does not mean that it is applicable. Understood? So every case is anyhow interconnected. Now let's just deal with the last passage over here, which is such encashment of bank guarantee cannot be treated as payment of duty or duty paid by a claimant. In such circumstances, the doctrine of unjust enrichment or section 27 would not be applicable. It is evidently clear that respondents are holding on to a money of the appellant which they are not authorized to do so as per the judgment of this case in Param Industries Limited. So that is not the authority with which the department authority should take law into their hands. So the encashment was unjustified, and thereby obviously Supreme Court is over here has by the impugned judgment of the High Court was set aside and directed the respondent to immediately refund the amount covered by the bank guarantees to the appellant. Since retention of such amount is unjust and unlawful, the same would carry interest at the rate of 6% from the date of encashment till repayment within 4 months from the date of order. Understood? So they have set aside the impugned judgment of High Court, where High Court has stated that doctrine of unjust enrichment will apply, taking up the support or the precedent of 2016 judgment. DCW का जो judgment था, taking up that judgment into hand, High Court took the reliance of this judgment and given the benefit to the respondent over here. High Court का इस judgment को set aside कराया गया and thereby immediate refund was taken into consideration with 6% of interest. Are we clear? So the issue before us, which was whether doctrine of unjust enrichment or section 27 or customs of custom act applies in cases of encashment of bank guarantee which was given as security, the answer is clear no. The unjust enrichment of section 27 will not apply in case of security. Please mark the words correctly. If it is given as a duty, yes. If it is a duty, इसके लिए जो केस है वो कौन सा है? आपका ओसवाल वाला केस है, ठीक है. बट इन केस इफ दिस इज वाज अ ड्यूटी, अगर मेरा इशू होता रिगार्डिंग ड्यूटी, तब मेरा मफतल लाल इंडस्ट्रीज लिमिटेड वाला केस एप्लीकेबल होता, ओसवाल वाला केस एप्लीकेबल नहीं होता, बिकॉज इट सिंपली लेज डाउन द प्रिंसिपल्स which are required to be followed. And in case of claim of refund, then one of the major important principle is application of doctrine of unjust enrichment. Are we clear with this case law? Do you understand doctrine of unjust enrichment? Do you understand section 27? Section 27 is nothing but an application for refund. And with that application, the second most important thing is filing the relevant documents to show that you have not shifted your burden of paying that custom duty to the customers or to some third party. Fine? Clear? Do you understand or do you have any problem? Yes or no? See, simply over here, DCW में क्या हुआ था? The High Court, or sorry, the court over here had ordered the authority to go ahead with the encashment. They had ordered because of the simple reason, because there was default on the part of assessee in paying the duty. So there was a default on paying the duty, and thereby the court has ordered the encashment and said the doctrine of unjust enrichment will apply. But in this case, there was this not duty which is paid, but a security which is being paid, and thereby when there was security, DCW वाला case apply नहीं होगा. Am I clear? Why Oswald is applicable? अरे भाई अगर इतना सिंपल वेरी सिंपल, ओसवाल में सिक्योरिटी की बात की गई है. बैंक गारंटी अगर सिक्योरिटी की तरीके दिया गया है तो ओसवाल हो रहा है, ठीक है. यहां पर कहीं पर भी मैंने रिफंड में कहा सिक्योरिटी नहीं, यहां पर ड्यूटी एंड टैक्सेस की बात हो रही है. देखो, रिफंड ऑफ ड्यूटी और टैक्स, दिस इज द मेजर डिफरेंस. कि मफतल लाल वाले केस में रिफंड ऑफ टैक्स एंड ड्यूटी की बात हो रही है, और ओसवाल में बैंक गारंटी सिक्योरिटी की बात हो रही है. हमारे केस में एज सिक्योरिटी दिया गया था, नॉट एज अ ड्यूटी और अ टैक्स पे किया गया था. इसीलिए रिफंड के केस में जब हमको देखना पड़ेगा, अगर हमारा सिक्योरिटी रिलेटेड है तो ओसवाल, वरना फिर मफतलाल. अंडरस्टूड? आर वी क्लियर नाउ? इसी केस में जो ये 2 जजेस बेंच का जो केस था, उसमें एज अ ड्यूटी था, नॉट एज अ सिक्योरिटी. इसीलिए हाईकोर्ट ने एरर किया. हाईकोर्ट को ये वाला डिसीजन नहीं अप्लाई करना चाहिए था, बिकॉज देयर वाज अ ड्यूटी व्हिच इज बीइंग पेड, नॉट एज अ डिफॉल्ट ऑफ पेइंग द सिक्योरिटी. आर वी क्लियर नाउ? तभी मैंने यहां पर लिखा अगर सिक्योरिटी है तो ओसवाल, अगर ड्यूटी होता तब हम मफतलाल के केस को रिफर करते. प्लीज रिवाइज इट once again. If you have any doubt, we will counter it in the next class. Thank you so much. With this, I'll end the session for today.
Enhance legal skills. Unlock success with RostrumLegal.